Welcome to today's podcast on privilege from a US perspective. Today, I'm joined by Jonathan Barbee and MoloLamken, and we're really going to look at how privilege can be maintained by in-house counsel and how in-house counsel can minimize risk. So welcome, Jonathan.
Thanks for having me on today, Emily. I'm really looking forward to discussing how privilege issues are handled in the U.S.
Brilliant. Okay, so we'll start at a high level. And what is the general position? So is advice that in-house counsel give to their business privileged?
So generally speaking, I would say that most lawyers and courts in the U.S. believe that whenever an in-house counsel is giving advice to the company or to employees at the company, then that advice is presumed to be privileged. Now, if it's challenged, then maybe there might be some reasons why certain advice isn't privileged. But I think for the most part, people understand that the reason why you have the in-house counsel at a company is because they're going to be providing legal advice of some sort to the business. And obviously, you may be having a conversation about a business issue, but the reason why you're likely to have a lawyer in the room is because there's some sort of legal issue there. And whenever the lawyer speaks, the lawyer is generally providing some sort of legal advice. But of course, there are exceptions to any rule. And I think one thing that lawyers here are becoming more aware of is the fact that courts more and more are paying attention to the fact that in-house counsel wear two hats. They wear their legal hat and their business hat. And so whenever a discovery dispute concerning privilege arises in a U.S. court, you have to be ready to deal with that issue. And I think that's been further complicated recently because more and more at companies, you have lawyers in more non-traditional legal positions. So maybe decades ago, you would have your in-house counsel and a company's employees would only go to that person with discrete, specific legal issues. Now you may have somebody who's some sort of vice president at a company, and yes, they're in a legal role, but they're also, in some sort of business strategy role too, and they're really straddling those two responsibilities. And so I think that's another thing that we have to be aware of, which is that in-house counsel need to be very, very conscientious about the specific role that they're playing at their companies.
Thanks, Jonathan. And do you think that job title or function makes a difference in that assessment? So if, for example, the legal counsel is not employed within the legal department, does that automatically mean that the advice they're giving to the company is commercial rather than legal? Or like you said, if they have a VP, something non-legal title, does that automatically sort of flag that their advice may not be privileged? Or is it the subject matter of what they're opining on?
It's really going to be the subject matter of what they're opining on. And legally speaking, it shouldn't matter what their title is or, which department they technically belong to. The way that will come up in a litigation, if you ever have to litigate a privilege issue, is that that's going to shape the narrative and the reasoning behind why an in-house counsel's advice was or wasn't protected by the privilege. So if they're just sitting and say a product management team and providing, advice directly to a team of engineers every single day, then it's easier for the lawyers on the other side during the litigation to make it seem like that person isn't really engaging in providing legal advice all the time because, they're on this product management team and most of the time they're just talking about the business issues with developing a product.
That's interesting. So I think it seems to be a quite similar position to Europe. So I spoke a couple of weeks ago to Colin Passmore, who is an expert on privilege in the UK. And his opinion was that in the UK, the lawyer has to be employed within the legal team to be able to say that what they're doing within the company could be privileged. So they need to be a lawyer working as a lawyer. Whereas I think, in-house counsel have worked quite hard over the last sort of few years, decade, to become more business partners within organizations. And so even if you are within the legal team, I think that there's still a role where you may have parts of your advice being legal and parts of it being a bit more commercial. Um, if that happens within the same email chain, for example, how is that dealt with by the US courts?
That's a really, really excellent point, Emily. And I think that brings up some of the trickier issues that I've faced and litigating privilege issues here in the US. And you bring up a good point about how some in-house lawyers can have these hybrid roles. And sometimes what you see too is you'll see somebody who's in a general counsel position who then gets elevated to become the CEO of a company. And in that situation, they may still be acting in their former capacity as a general counsel sometimes, but clearly they're not just in that legal function anymore. And what happens in that situation? And so going to the email communications, the reason why that's tricky is because sometimes what you'll have is an email communication that has a blend of both legal advice and say business advice, and then that becomes very, very tricky. And it's really hard to say how that would be dealt with here in a U.S. court because it will partially depend on the case law that's developed around privilege issues in a particular district court or a particular court of appeals. And it will also depend partially on each judge's individual views of those issues. And as we all know, when you're dealing with a potential privilege issue, everything is nuanced and very, very unique. So it may depend on the in-house lawyer's role. It may depend on who's CC'd on the email. It may depend on the purpose of the conversation. All of those things can factor in. I think the other thing too that's considered when it comes to email chains is whether you can really parse apart the legal advice from the business advice. So for instance, there may be a situation that comes up where you have an agenda for a meeting and some of the items on the agenda relate to legal advice. Is the strategy appropriate under a certain statute or regulation? And then other parts of the agenda have nothing to do with legal advice. It may just be scheduling a meeting, or it may just be providing an update on revenue or something of that sort. And so in that situation, what I've seen is that you can actually break apart the legal advice from the business advice. And then if you get in a situation where you're litigating the issue and the non-privileged information has to be produced, then there can be a way to redact the legal advice portions of an agenda or some document while still producing the non-legal portions of that communication. But it gets really, really tricky because sometimes you may have legal advice embedded in an email or some other sort of document, and it's just not clear that that's legal advice. And then you're going to end up in some sort of fight about that. And unfortunately, sometimes you may end up just having to produce the entire document. So I'm sure we'll get to this later on, but I think that's why in-house counsel want to be very, very conscientious and cautious about how they're setting forth legal advice and communications. And if there's going to be any sort of doubt about whether that legal advice will be understood as legal advice or business advice, then it may make more sense to just put that legal advice in a separate communication or a separate document.
Yeah, good advice, Jonathan. I think some of the problems happen where you've given some advice and then the people on the chain start to discuss that advice and how that advice can apply in the commercial context. And then suddenly you have this kind of spiraling out of control communications chain. So, I mean, you mentioned the agenda and part one, part two, so legal, non-legal, and how to kind of partition out advice. But what are the other practical steps that in-house counsel can take to ensure they maintain privilege in their own advice? And then we'll come on to talk about advice that's being received from outside counsel.
I think there are a few things that the in-house counsel can do to ensure that the legal advice that they're providing is protected and maintains its privilege, especially if it ends up in litigation. So as I mentioned, U.S. courts are very aware that in-house counsel wear two hats. So in-house counsel just need to be very, very aware of that. And I think not only should they be aware of that, but they should ensure that they're communicating to their audience which hat they're wearing. Yes, I'm giving you legal advice right now, or no, I'm not giving you legal advice right now. We're discussing a business issue. And make it clear when you're transitioning in communications, whether it's verbal or written, between the legal side of things and the business side of things. Related to that, I think it would behoove in-house counsel to label their communications as privilege or legal advice. Even if it's something that's being communicated verbally at a meeting, there doesn't seem to be any harm in saying, hi team, I'm about to provide you with some legal advice about this particular compliance issue. Just so that if it ever comes up later in litigation, even if one of the attendees at that meeting is deposed, they can say, I can't share with you what was discussed during that meeting because the lawyer told me at the beginning that it was privileged. So that's an extra precaution that in-house counsel can take. And I think the other important consideration is for in-house counsel to think about how sensitive a particular legal issue is or a particular communication is. If it's just a routine piece of advice, then maybe you won't need to put as many protections into place. But if it's something that's very, very sensitive, such as whether a company is infringing on a patent or potentially engaging in some sort of act that will incur liability, then I think that's all the more reason to put additional protections into place, which can include labeling the conversation as privileged advice, making it clear that you're wearing your legal hat, limiting the audience, making sure that the legal advice isn't disseminated too widely. Because as you mentioned earlier, Emily, you can have issues with that. Even if the dissemination of that advice shouldn't break the privilege, again, if this comes up in litigation, it can just be harder to prove that the privilege was maintained. For instance, I was thinking about a scenario where you have an in-house patent counsel giving advice to one employee that they don't infringe a patent or that they do infringe a patent. And then there's a second conversation where that employee talks to another employee and says that it's okay to copy the competitor's product. So in that situation, in court, you could argue that the first employee was conveying legal advice to the second employee, just as if the in-house lawyer had talked to that second employee, but it just won't look good in the record when that comes out. And then, that can cause you issues. And then I think that there are a couple other things that in-house counsel should consider too. So in the US, when it comes to privilege issues, you're always worried about whether the privileged communication will be challenged in litigation. If the privileged communication isn't challenged in litigation, then you really don't have anything to worry about. So another thing that in-house counsel should think about is the likelihood that the advice will become part of discovery in a litigation. Again, if it's a routine everyday issue, that's probably not going to be litigated. If you're talking about the prospect of engaging in actual litigation, there's a good chance that that issue would be litigated. And then related to that, in-house counsel should also think about whether they would care if a particular piece of legal advice is deemed not to be privileged by a court and you have to produce that in a litigation. And it may be that you actually don't really care about some communications that are technically legal advice. Yes, we're going to keep producing this product because we believe that we're complying with all of these regulations. If that comes out in litigation, that's not harmful. And that's probably something that a business person would say anyways. But again, if it comes to issues about whether there's patent infringement or not, obviously you wouldn't want that to be disclosed.
That's really helpful. And I think, in-house counsel are quite used to assessing different risks to the business, and the risk of their own advice being disclosed is something that they should be able to do. And yeah, I think it is, what is the risk that there is going to be some sort of issue in court which will require disclosure? That's sometimes difficult when you're talking to non-common law governed people. So here in continental Europe, there's no real disclosure. So privilege doesn't really have the same impact as it does in the UK or in the US. One thing that we have in the UK is different types of privilege. So we have legal advice privilege, which is quite narrow, but we also have litigation privilege. So if litigation is contemplated, then the communications around the litigation from the lawyer are all going to be privileged. Do you have a similar kind of differentiation for when legal proceedings are contemplated in the US, or does the more narrow kind of what I call legal advice privilege apply in those situations as well?
We have both types of privilege here in the US. So the legal privilege that you were talking about is what we refer to as the attorney-client privilege, which also takes some other sorts of forms, such as the common interest privilege, which I'm sure we'll talk about shortly. And then the second bucket of privilege falls under the work product doctrine, as we call it here in the US. So that's a privilege and a protection that covers communications and work product that's prepared for litigation or anticipation of litigation, with understanding that if you're faced with a litigation, certain employees may be preparing documents for that litigation without a lawyer present or monitoring the activity. And practically speaking, you need to be able to have that type of communication and work product protected.
So you mentioned common interest privilege, and I'm most familiar with that when considering sharing privileged documents with third parties. Obviously, as a funder, we're a third party, and in order to make our risk assessment as to whether to invest in a case, there's certain information that we need to receive about the case. And some of that could be information from in-house counsel or from the outside law firm that is instructed. In the US, how do companies safeguard information when sharing with third parties like funders?
That really all depends on the situation and the parties involved. I think that the safest rule to follow is to just not share your own legal advice with third parties unless there's a good reason to do so. And unless you have a special relationship with that third party that could lead to protection from the common interest privilege. So here in the US, generally speaking, for the common interest privilege to apply, you need to have a common legal interest with that third party in some sort of shared or aligned interest and some sort of legal issue. And courts are slightly divided over the line between when the common interest privilege applies and when it doesn't apply. So for instance, it may be that your company and its joint venturer, which is a separate company, have a shared business interest in starting this joint venture and dealing with all the legal issues inherent in that joint venture. I think generally speaking in that situation, the parties would assume that the common interest privilege does apply there. And even though the common interest is grounded in a business partnership, like I mentioned, there are definitely legal issues bound up in that business relationship. But again, if that relationship and those shared interests are challenged in a litigation, it could be that some courts find that that shared business interest doesn't extend to some legal interests. And I think the other thing too that parties have to be very careful about is that whether or not the common interest privilege applies to their communications can change over the course of their relationship. So at the beginning of the relationship, it may be that it's harder to argue that the common interest privilege applies because at the beginning of the relationship, the parties don't necessarily have that shared interest. They're still deciding what that shared interest is going to be. They're still building that shared interest. And some would actually say that their interests are at odds because they're evaluating each other. They're negotiating over the terms of their relationship. And that it's not until later on in the relationship, once they've established the shared business interest, the shared legal interest, that the common interest privilege applies more securely. So you have to think about that as well. And when it comes to litigation finance and litigation funders, I think that same dynamic applies as far as looking at how the common interest privilege would apply, say, during the due diligence process, where the parties are still feeling each other out, looking at the terms of the agreement versus once a deal has been signed, you're actually in a relationship with somebody. So I think it's good to be very, very aware of the distinctions between, those different phases and a relationship.
Thanks, Jonathan. That's really helpful. Let's sort of turn our attention now to incoming advice to a company. So when in-house counsel instructs a law firm to provide advice to the company, and then the in-house counsel then needs to implement that advice within the company, how what's the best practice for in-house counsel in terms of sharing advice within the organization which has been obtained from outside counsel? So how does in-house counsel maintain privilege in advice that's been secured from an external counsel?
In that situation where in-house counsel receives legal advice from outside counsel, I think you have a natural buffer there because when that legal advice is conveyed by the in-house counsel to the company, to employees in the company, then I think mostly U.S. courts would view that as the same scenario where the in-house counsel is coming up with that legal advice on its own without the input from outside counsel. And so I don't know that there's a big distinction between those two scenarios. So I think the same cautions for in-house counsel would apply, which is to make sure that you're careful about how broadly the legal advice is disseminated, to apply the necessary disclaimers or labels to ensure that people know that it's legal advice, to make sure that it doesn't get outside of the company to a third party, because in that situation, even if it's a slip up, then it could be argued that that slip up broke the privilege. So you also want to be careful about that. And then, as we talked about earlier, especially when it comes to email communications, it can sometimes be easy to lose track of the legal advice, or the legal advice can seem to morph into business advice, so that at the end of this long chain of communication, what still is technically something that derived from the legal advice just doesn't look like the legal advice anymore. And it's really, really hard to connect that final communication all the way back to the legal advice that was received from outside counsel. So I think it's good for in-house counsel to just be very, very conscientious of that, because again, at the end of the day, you're really thinking about how these issues would play out in litigation. And in the US, as you mentioned, Emily, we have to deal with a lot of document discovery. And then you can end up in a lot of fights about trying to prove that email number 20 actually did come from that original email from outside counsel.
Yeah, I think in-house counsel, it's quite difficult sometimes to manage the internal communication and as you've said, making sure that people are clear as to what they can and can't do with any information, and trying to shut down the spiraling email chains is helpful. Um, I think last question. So, um, if you are employed within a group of companies as an in-house counsel, and you're not just advising your employer company, but you're advising other group companies, so maybe some subsidiaries, it's not the same corporate entity, but it's the same group. Is there any kind of difference in the position on privilege? And I think the second question is if that entity is in the UK, for example. So you have US counsel sitting at group level in the US, providing their advice to a UK entity. Um, does that still cover, is privilege still going to cover their advice? Or because the US law is not qualified in the UK, will there be a bit of a gap there?
When it comes to companies sharing legal advice with their subsidiaries, generally speaking, we still see the attorney-client privilege applying throughout an organization between the parent company and its subsidiaries for the most part. And I think, generally speaking, when privilege issues come up in U.S. litigation, the parties generally aren't fighting about whether there is communication between two subs or between a parent and a subsidiary. That being said, I think that sharing legal advice between a parent and a subsidiary can lead to some tricky privilege situations in certain scenarios, because it could be that at some point a subsidiary's interests become adverse to a parent's interests. So you could potentially have that situation when it comes to bankruptcy, or a situation where a subsidiary is in the process of being acquired by another company. So obviously, when the subsidiary is still part of the original parent company, I think it's pretty safe to assume that the privilege would apply to legal advice shared between the parent and the subsidiary. But obviously, as well, once that subsidiary is acquired fully by the second parent company, then that subsidiary no longer has that shared legal interest with the original parent company. So then again, you have that gray area in the middle of the transfer of the subsidiary from the first parent to the second parent. And so I think you could have some dicey issues about when the privilege no longer protects the communications between the subsidiary and its original parent. So in-house counsel should just be aware of those types of situations. And then as far as the geographic location question about whether, the subsidiary is in a different country than the parent company, and about whether, say, a U.S. lawyer is providing advice to a foreign subsidiary, generally speaking, I haven't seen those issues really come up in U.S. litigation. So whether I'm providing legal advice to a client here or a client in Europe, the privilege should protect those communications equally, at least when it comes to litigating and proving those issues in U.S. courts. Because it wouldn't be fair for my legal advice to be protected when my client's here, and then if my client gets transferred to the European office of the company, then I can no longer talk to them about the same legal issues. So I haven't really seen that type of distinction about geography or location come up. But I think that is a valid point, that privilege rules are different in different jurisdictions and different companies. And so obviously you want to be aware of that, because just because a communication is protected here doesn't necessarily mean that it will always be respected across the world.
I think that's right. So being an in-house counsel is really difficult sometimes because you're qualified in a specific jurisdiction, but you're advising your business more broadly, and then having to kind of have an extrapolated out mind to what the law could be, and taking a view on how you need to structure the way that you're presenting your advice is sometimes quite difficult. But I think from our conversation, it's been really useful. Thank you, Jonathan. I've taken a few key tips away. So firstly, assess the risk. If it's probably not going to end up in litigation, it's less of a risk. And keep control of your communications, and think about whether you're giving legal advice or commercial advice, and make sure you keep the two separate. So if there is a dispute, then it's much easier for those who have to review the documents to be able to separate out the privileged advice from the general commercial advice from a particular individual. Thanks very much, and please join for our next podcast.